Hi, everybody. I'm Tarun Khurana. I am from Khurana and Khurana IP Attorneys. Thank you very, very much for joining in. We are just at 4 o'clock, so we'll immediately start off. Thank you very much for joining in and for yet another session. We are doing this webinar after a fairly long period of about a month and a half or two. And I am glad to have a close friend and colleague and acquaintance, Vincent Joes, with me. And the outline of the session was to focus on anti-counterfeiting practice from a criminal perspective. As we all are aware, there is a civil side to enforcement and there is a criminal side to enforcement. And therefore, this session essentially was targeted more towards trying to give some practical aspects of how the criminal aspect of counterfeiting can be taken care of. And from that perspective, very happy to have Vincent with me. We'll be glad to have questions through the session. Please don't wait to ask questions. Like, we can always pause and try to answer the question because it will be relevant for the whole colleagues at large. And Vincent, do you mind giving a quick background so that we are all together as to what your focus areas are and what InstaQuest is all about?
Sure. Thank you, Tarun. Thank you very much for having me on this webinar. Uh, yes, as Tarun said, we've been an acquaintance, we've been friends for quite some time in the field of IPR without stepping on each other's shoes. So essentially, InstaQuest Consulting Private Limited is an investigation and research agency. We have been in this particular field for over 8 years now. It was incorporated in 2012. During my presentation, I would share a bit about what our expertise, our field has been, what all we've been doing. We've been doing a lot of IP related work. It includes not just investigations and research, but also criminal side enforcement in all industry categories, in all verticals, be it pharma, be it clothing, apparel, and so forth. So yes, that's a little bit about InstaQuest. I'll elaborate more during the presentation.
Oh, absolutely. Thanks. Thanks very much, Vincent. Again, thank you again, everybody. Before we start, I thought I'll take about a few minutes to give a very quick background about what counterfeiting is all about. And there is always this level of confusion that most of the members outside the bar and outside the legal fraternity have as regards counterfeit versus piracy. And are they really the same, or is there a difference between the two aspects or the two kinds of infringement activities that take place? And therefore, I thought I'll clarify by stating that counterfeit essentially is an unauthorized imitation of a branded good, which means that if I look at Louis Vuitton or if I look at Woodland as one of the items that I intend to counterfeit, then I will really make my own purse or my own footwear or my own bottle or whatever that product might be, and will essentially imprint or use the trademark of the entity that I'm trying to prepare a counterfeit for or that I'm trying to manufacture a counterfeit of. So it will not really be the same product per se. It may be a different product. It may be made of different material. It may have a different aesthetic appearance. It may have a different appearance or an outline to it. But I'm using the same trademark as that of the other brand that I'm trying to make a counterfeit of. And then I'm using it for different products that I'm making. Piracy, on the other hand, like is what happens in the software cases majority of the times, where you have pirated content of Adobe or Symantec or Microsoft or other and large entities where there are software. And in case of piracy, there is an exact copy or a replica which is made of the original product of the branded company. So you actually have a CD of MS Office and then you'll make 1,000 copies of it. So the content used is obviously the trademark is used, but along with that, it's the exact copy of the product that we are trying to prepare a pirated version of. And therefore, in counterfeit, the product can actually vary. It can be, if Louis Vuitton doesn't really make, for example, certain kind of clothing accessories, but if I make a clothing accessory line, but I start writing LV on it, it'll be a counterfeit product. But if I actually make an exact replica, it'll be a piracy. as regards the unauthorized copying of that article is concerned. And therefore piracy is, because it's difficult to make an exact copy. Therefore, the term piracy is usually used in the online space where there's a possibility of literally copying the whole source code, literally copying the whole binary code or the object code, or essentially in other instances where there's an exact copy possible. Now, having said so, what are the relevant provisions under law under which we can actually go and try to enforce when there's a counterfeit action that intends to be taken up? One is obviously to file a civil suit in an appropriate district court or in a high court that has original jurisdiction, where we can actually file a 3912 application seeking interim injunction. We can have an order 26 application where we can ask for a local commissioner to be appointed. And then there are other, the whole civil trial sort of goes on, where you have benefits, or sort of you can outline not only monetary damages, but you can also claim injunctive reliefs. But if you're talking about the criminal side, we essentially have the following provisions, which I'm sort of sharing in the slides. There is section 102 and 3 of the Trademark Act, which talks about an imprisonment for a term of not less than 6 months, but may extend to 3 years with fine. And there is a fine also quantum also associated to it. So that's one provision under the Trademark Act that you can essentially go, which would require you in most cases to have a registered trademark or a pending application which is associated to a registered trademark, or depending again on the provisions and the authorities in front of which you are trying to enforce or trying to get the seizure and the raid done, if they're actually mandating or rely on a pending application. Then you also have provision under the IPC which are relevant from 482 to 486, which are read with 420 in usual cases, where 482 talks about punishment in using a false property mark. 483 talks about counterfeiting of a property mark used by another. And then there is 485. 484 is about a property mark being used by a public official or a public servant. And therefore I sort of skipped that. But 485 talks about making or possession of any instrument for counterfeiting a property mark. And then we have 486, which talks about selling goods which are marked with a counterfeit property mark. And it talks about how we can take an action, where we can take an action. And then as we can see, that talks about punishment which may extend up to a year or with fine. And therefore you may want to mix it up, match it up with the Trademark Act so as to make a stronger case on the criminal side. There are also provisions under the Copyright Act to go through the criminal route, where there is section 63, which talks about an offense of infringement of copyright or other rights conferred in this act, where anybody who is sort of infringing or abets infringement of a copyrighted work essentially can be punishable with imprisonment for a term of not less than 6 months, but may extend up to 3 years. And the same clause which was there in the Trademarks Act as well. So these are the main provisions under which you can essentially initiate criminal proceedings, either directly through the police or through a local magistrate, wherein in practical scenarios, if actually the police denies taking any action based on a trademark infringement, we can file an application under section 156(3) of the CRPC before the first class magistrate, who can then issue an order to the local SHO to carry out the investigations and lodge the FIR. What we can also do is, if we want the raid and the seizure also to be conducted and the raid and the search to be conducted, then an application under 93 and 94 of CRPC has to be filed along with the above request under section 156(3). And then if we do not go to the police, we don't want to go to the police and we directly want to get an order from the court first, then we will essentially have to file a complaint under section 200 of the CRPC. And upon the satisfaction, the magistrate may issue an appropriate order and issue summons to the accused. This, however, as you would see, point number 6 talks about a scenario where we don't go to the police and we directly want to file a criminal case or a suit in front of the local magistrate. Whereas point number 4 talks about the fact where we've gone to the police, they've not cooperated in this context, and therefore we file an application under 156(3), where we then get an order under the CRPC and then go back to the police, who will be obligated to then carry out the orders based on what the order looks like. And then the seizures, search and the seizures go on. In practical scenarios, obviously, when we do these raids, there are various practical difficulties that we obviously feel when we're sort of going to the police, their expectations, the fact that they would need a registered copyright, which again is not a requirement under the statute, but if you're taking shelter of section 63, they may ask, if you file for a copyright, show us the registration certificate. In case of trademark, they may ask for a certified copy. Sometimes the police doesn't understand, so they may not cooperate from that perspective. Obviously, there are numerous instances where the police officials are not comfortable going ahead and conducting the raid because the area is sensitive. So there are very many practical difficulties that are faced during criminal proceedings of this nature that Vincent will talk about. And I will give a few examples from very many raids that we've conducted in the last many years. In addition to that, I also wanted to talk for a few minutes on civil versus criminal proceedings, because this is also a question that branded companies ask us, of what route should we take and which one is better. And I think there are pros and cons for both. On the civil side, while we can ask for injunctive and monetary reliefs, the reliefs that we get under the criminal side are only imprisonment, essentially, and perhaps a fine. And we can obviously implead multiple parties. So you can have the main trader, you can have the distributor, you can have multiple parties being impleaded or being added as defendants in the civil suit, which becomes difficult in the criminal proceedings because every cause of action is independent. Whereas in a civil suit, you could really have 5 retailers put together if they have a common cause of action. We can also have John Doe orders where there are unnamed defendants, and therefore if we don't know the details but we are confident and are able to satisfy to the court that there is very clear evidence that there are other parties that we don't know the names of, but if there is an order, it will help us to sort of identify those names. Or if and when there are future infringers, we would like to use this order against other future infringers as well. So we can also obtain John Doe orders, which otherwise is not practically possible under criminal proceedings at all. We obviously under the civil proceedings, by virtue of the proceedings going on in courts and the lawyers' fees, and by virtue of the criminal proceedings being between the state and the infringer, the costs are much lower because we as investigators, or we as people who enforce, only become witnesses. But in the case of a civil suit, by virtue of it being a party-to-party matter, the costs obviously are far higher, and therefore that becomes a major detriment in case you wish to file civil suits against multiple parties, because it eventually ends up being longer and far more costly compared to criminal proceedings. Also, it's more cost effective, as I said, to file sort of process matters under criminal proceedings. But again, there's a contrast to it where civil proceedings have more enforcement, they're more effective because we can initiate contempt proceedings in case the orders are not complied with. The contempt petitions are taken up very seriously, could again lead to imprisonment, could again lead to fines, and there are fines to the tune of 3, 4, 5 lakh rupees that we hear nowadays on a relative or regular basis. And that's therefore a big detriment that also gets created by the civil proceedings as regards enforcement is concerned. Civil proceedings tend to have more meaning and more relevance if we are filing it against bigger parties which are in the regulated space. Filing it against small retailers or shopkeepers, which are umpteen in number, may make it unviable for us to have or sustain civil proceedings, and therefore civil proceedings tend to be more effective when you're trying to fight it against a company that you would really want an injunctive relief against, and that will in all likelihood sort of concede to the injunction that has been imposed on it. Under the civil proceedings, it's also important and relevant to understand and sort of differentiate of whether you would like to go through the district court or through a high court having original jurisdictions. The minimum monetary damages that you can seek are obviously the thresholds based on which the court fees are decided. And therefore, if you go to the high court, you're looking at 2 to 3 lakh rupees, depending on which court are you in, for you to enforce and sort of initiate legal proceedings. And therefore, only in high stake matters where an injunction really plays a big role is where parties would essentially go down to high courts and initiate proceedings there. also criminal proceedings are have a more short-term impact. They cause a social deterrent or a social embarrassment on the accused, and therefore, if you are comfortable or if you're happy with a short-term impact and trying to give a knee-jerk reaction to the whole situation, then perhaps a criminal proceeding may make more sense. But if you're looking for a long-term resolution to a particular issue, or if you feel that the parties on the other side, once injuncted, will have serious consequences and serious economic impact on their business activity, criminal side definitely makes more sense. And again, last point is very obvious. Sometimes it becomes difficult to coordinate with the police, and during the searches, during the seizures, the quantum of goods that you are able to seize, and then how much is there an arrest that actually happens, how quick is the FIR lodged, and what are the proceedings after that. All of these are practical issues that we have to look at before we decide whether to go on the civil side or on the criminal side. So this is what I thought. I'll just lay the ground very quickly as to what the key difference between piracy and counterfeiting actions are. What are the legal provisions under the Trademark Act, under the IPC, under the CRPC, under the Copyright Act, and then civil versus criminal proceedings. What are the practical differences, and what route can we take would depend on many strategic aspects. Few of the parameters having been laid down here. Vincent, I will open it up for you now. Why don't you share your presentation and sort of take us forward from here? Vincent, you're on mute. Can you unmute yourself?
Yeah, I hope I'm audible.
Yeah, very much audible.
Yeah. Thank you, Tarun. Thank you for uh, giving me the opportunity to present my presentation. Just sharing my screen.
Yes, Vincent, we can look at it.
Quickly turn into slideshow mode. So, as per the initial introduction, InstaQuest Consulting Private Limited is the company that I'm a part of. Incidentally, I'm the founder of this particular organization. Right after the introduction that Tarun has given, I thought I'd dive in directly into the impact of counterfeiting on brands. Dive into the core of it, the predominant impact that counterfeiting has on brands is primarily loss of sales and profit margins. Uh, Apparently, because the counterfeits eat into the market share of the brands. There is an increased production cost uh, because of the impact of counterfeiting that happens in the market. There are product liability claims, as we've seen in some of the high-profile cases where there are consumers who are filing complaints against brands for substandard material, which apparently is not a fault of theirs. It is the counterfeiters who are causing loss of face value for brands and so on and so forth. And of course, there is the brand and product reputation damage, as we have seen in most of the cases that come to light. A few figures, we'll talk about a few numbers. These are the major uh, uh, impact bearers of counterfeit. So there is sales losses in terms of billions industry-wise. So if you see, there is clothing, pharmaceuticals, cosmetics, watches, handbags, toys, sports goods. So in descending order, this is the impact that counterfeiting has on brands. I'll quickly move to a little bit of introduction about us. We are an organization incorporated in 2012. have investigated over 500 brands, completed over 6,000 investigations. We have a collaborative presence in about 7 South Asian countries. And we have ourselves conducted investigations and conducted enforcement in a few of these countries that include India, China, Bangladesh, Sri Lanka, Indonesia, Singapore, and Nepal. The IP domains that we cater to: trademark, trade dress, patent, copyright, industrial design, transfer IP. I'll just quickly run through them because then I would move to the most interesting part of my presentation, which I always like to share, which is case studies. These are a few of other expertise of InstaQuest, the industries that we serve: medical, pharma, fashion, food and beverages, and so on and so forth. Right. Now comes the interesting part. So uh, whenever we speak about IP, when we speak about IP and brand protection, this is my favorite line that I always use, that if you're famous, you would be copied by somewhere. A classic example is this particular case study. For obvious reasons, I wouldn't be able to share the name of the plaintiff or the defendant. So this was a matter that we had investigated in the year 2016. It essentially was a trademark infringement, but it was a very carefully crafted trademark infringement. So it was a tire manufacturer. It's a huge brand. It's a global brand, which was being copied with a slight change in the spelling. And this was being manufactured down south in Kerala, a huge manufacturing facility over there. And these tires weren't being supplied in India. They were being supplied to Nepal via there is a border town called Raxaul between India and Nepal, and the tires were being exported there. The client came to us. They told us that there is a potential infringement that is happening. They wanted us to unearth the modus operandi of the target, uh, and we started the investigations. During the investigations, initially we only had information about the infringement happening. We didn't know where was or which way was where the infringing material routed. Once we found that the manufacturing facility was present, it was manufacturing infringing products, then the interest shifted from identification of the target to understanding of the modus operandi of the target. That is when we actually went ahead and sorted through the export data. And we found that a lot of export was being conducted by this entity to Nepal via Raxaul. Once we investigated, we found that this was being transported by road. The products were being transported, the tires, it were essentially tires. They were essentially tires. They were transported by road to Nepal. Once we had all this information, we gathered evidence. Evidence was, of course, import-export data. Then we had product brochures. We had invoices by way of procuring infringing material. And eventually, we had enough material to go after this particular entity. It has been, it's a famous case. It was filed in Delhi High Court. It was not a criminal enforcement as such. It was the civil route that the client chose to take because of the size of the entity, as Tarun mentioned earlier. So this has been one of the classic examples of how we investigated potential trademark infringement. The next, this is one of my favorites. Uh, uh, and you would know why we use this particular phrase. If you do not take your intellectual property seriously, nobody else will. So this was a case of a European valve manufacturer, plumbing valves manufacturer, who had a single distributor in India. Now, this single distributor was solely responsible for the entire sale and circulation of valves across India. It so happened that over a period between 2012 and 2015, the imports from the European entity into India plummeted, and they found that something was amiss. So one fine day, a lawyer friend of mine calls me up and says, "Why don't you come over meet a client of ours who's down here from Europe?" Once we found what was the matter, we wanted to get into the depth. The objective of the investigation was to identify whether the sale of the product actually had declined in India, or was it some foul play happening. When we investigated, we realized, so it was a survey conducted across construction sites across 10 cities in India where the products were being supplied. When we unearthed the documents of the procurement of these particular valves across all these construction sites, we actually found that the sale of the products never decreased. And when we dug further, we identified that the distributor was actually importing counterfeit products from China of this particular brand, of the European brand, and he was mixing them with the original products and supplying it across all construction sites. Now, counterfeit plumbing equipment could be a disaster for any commercial or residential establishment. So it was definitely a serious issue uh, to be looked into. Once we identified through import-export data, we found that there was a warehouse in Chennai where the distributor was housing all the counterfeit products. We gathered evidence. Uh, the distributor was went to the extent of filing a trademark on the name of the brand in India, which the brand never had filed in India, and the client wasn't aware of it until we discovered that there was a trademark filed in this particular. And then we found caught hold of the uh, warehouse. We found the infringing material. There were counterfeits. And once we had a police action taken, the client moved to court, and the case was fought in the Madras High Court. And that is how we sort of caught hold of someone who was within that supply chain and who was dealing in counterfeit. Thankfully, today they have more than one distributor. They have about 10 distributors. They've realized over a period of time that one should not put all their eggs in one basket. So that was one of the classic cases that we had to solve. Yeah, mimicry is funny on stage, not in business. This was a case that we solved during the lockdown, incidentally. Um, I had mentioned this to Tarun a short while ago. So this was in April 2020, that is during the lockdown period. One of the leading PVC pipe manufacturers in India had come across counterfeits being supplied across North. And this is a client of ours who a technology solution that we have for identification of infringement. I will come to that later. Once we identified the counterfeit product, we had to unearth the perpetrator behind the manufacturing of these counterfeit pipes. It had to have a factory setup because manufacturing of pipes is easier, but you need to have printing material to have the exact copy of the brand that they are infringing. So once we started investigating, we found that the roots were somewhere in Barnala, Punjab. Uh, but it took us almost 3 weeks to actually locate the factory because the location of the factory was on the outskirts of Barnala uh, in a very old factory setup, which from outside looked as if was desolate and was actually uninhabited, and nobody was allowed inside. But during the course of investigation, we were fortunate enough to gain entrance into the factory premises, and we actually found counterfeit PVC pipes of the brand that we were investigating for. Once we had the evidence, obviously we took the next course of action. We approached the local police. We identified the location with the local police. We informed them about uh, the infringing activities that were being carried out. A raid was conducted, and the perpetrator was arrested with a lot of counterfeit pipes, PVC pipes, as well as the printing machines that were being used to identify to actually manufacture the counterfeit pipes. So this was one of the latest cases. Right, we move to the next case study. Um, we always keep saying that imitation is the best form of flattery. It's just not valid in IPR. So this was another classic case of counterfeiting of a branded lighter. So these are gas lighters. Essentially, this client of ours, who the US-based client, who had manufacturing facilities in China itself, had found some counterfeits being supplied across India. So we conducted market surveys and identified infringing material, counterfeits in fact, in Mumbai and in Delhi. And once we started our investigations, we found that none of these lighters were manufactured in India. Apparently, they were being imported from China. And then the client wanted us to actually unearth the modus operandi of these particular infringers in India. They were basically importers. And for that, we had to go to China. So we actually went into China under the pretext of an Indian distributor of lighters to make it more believable, because there was already a nexus that was being run, a racket that was being run. We were fortunate enough to be able to visit one of the biggest trade fairs in China, which is called the Canton Trade Fair. And from there, we identified manufacturers of lighters who were supplying into India. And by way of engaging with them, we were able to, we were invited into their factories. And that is where we found that counterfeit lighters were being manufactured and being supplied into India. Once we had the information, once we had enough evidence, we handed it over to the local authorities there in China. And then a criminal enforcement was conducted with the local police in China, with through the client, of course. And two factories that were manufacturing counterfeit lighters were identified and seized. And the next case study is, compatibility cannot replace novelty. This is a classic case of how counterfeiters can manufacture products and supply it under the garb of being a compatible product. So here they are not claiming that they are the actual product. They are saying that we are manufacturing products which are compatible. Now, essentially, this is a case of stone crushing equipment. It is a patented product, and the client of ours supplies stone crushing equipment across India. But there are many other smaller players who manufacture and supply spare parts of this stone crushing equipment to customers across India at a cheaper cost. And they do not claim that these are the original spare parts. They openly and blatantly inform that these are compatible products, whereas it actually amounts to patent infringement, because they are making spares which are not supposed to be used in the original product. This has been an ongoing process that we conduct for this kind of ours, where we procure infringing material, we procure compatible products from the perpetrators across India. We create evidence, and necessary action is taken against each one of them, depending upon the size of the entity. Some opt for criminal enforcement, while some go civil route, as Arun had earlier indicated. Yeah, so these have been the case studies. One of the latest news that I happened to come across today was uh, what are the uh, what are the measures being undertaken by various governments. So I came across this particular news article today where European Commission has actually prepared a watch list. It had actually prepared an initial watch list in 2018, and lately this year in 2020 they came up with the second version of the watch list where it includes a list of marketplaces and service providers who are engaged in counterfeiting and piracy across Europe. uh, Now the question is, this is Europe, this talks about Europe, what about India? Is there a watch list in India? Do we have a list of marketplaces and service providers engaged in counterfeiting and piracy? uh, well, I haven't heard of any so far. Uh, Tarun, you might want to throw some light later if there is one that actually maintains the database. Tarun, you wanted to say something?
Not really. It's a very fragmented market, Vincent, on this front. Obviously, there are databases which are available from the import export categories, and also the trademarks that get registered at the customs that we can sort of get certified copies of, and sort of do a brand by brand analysis, but not really a watch list which is coming out from a regulatory framework which can indicate what kind of infringement is taking place, and what kind of brands to what extent, and what kind of actions have been. So surely not in the manner that the European Commission sort of seems to have been implemented.
Agree, agree. So there's a small step that we are trying to take in this direction, where of course it is not in conjunction with the government or the local authorities here, but we have something called Copy Kitten, which essentially is a repository of potential infringements which are brand agnostic. When I say brand agnostic, we are not identifying potential infringements for brands that are working with us or registered with us, but we are identifying potential infringements for brands across the domain, irrespective of whether they are working with us or we are working with them or not. So this is a small initiative that we have taken. It's like I said, it's a repository. We already have over 2,500 infringements from across India. These are not just from the online or the online e-commerce market or the trademark journals, but also from the physical marketplaces, since we are always in the field identifying potential we detect leads, we verify it through our experts, and we upload it on our portal, which is CopyKitten. And if anyone who subscribes gets a customized dashboard where he can get qualitative and geographical analysis of infringements that are happening on their brand. We give a one-click report and so on and so forth. There's a little bit of what we are trying to do, bring in a little bit of change through our experience, and to also be understanding that there is a lot of technological intervention that can happen in this particular field and enable brands to be able to protect themselves against infringements and counterfeits. A little bit about our global reach. We have partners across these particular countries. And we always believe that IP protection is directly proportional to IP innovation. When I say IP innovation, I would refer to what are the different means and methods that brands can employ in order to protect their IP against counterfeiters and against any other form of infringers. So before I just wind it up, just a couple of initiatives that we are trying to do is we would be launching a CopyKitten app for both Android as well as iOS in 2021. This enables any person with a smartphone who finds a suspicious product to click and upload it on the app. It directly gets reported to the brand, the respective brand, and the brand with the geographical location where that photo has been clicked. and with the image, and it gives real-time information to the brand to be able to identify and take the necessary action. So, and then of course we have another initiative called IP Health Index, where a brand can get qualitative and quantitative uh, analysis of their brand protection programs, which they can use uh, in order to strengthen, fortify their brand protection. So, yeah, that is all I have in this particular presentation. Thanks, Tarun.
Thank you, Vincent. Was an absolute pleasure. Thanks for all the examples. I think they give a lot of clarity to the different approaches that can be taken during such enforcement actions. There are certain questions that obviously come to mind and have also been asked by Mr. Malik and a few other people in the chat box about the second and the third tier level enforcement, where we are trying to do it in second or the third tier cities. For example, we were representing a television company, TV manufacturing entity, and they were wanting to do some action in one small suburb of Indore. And the main hassle was that the retailers that we were sort of going out to, they were selling unbranded televisions. So there was nothing at all as regards what was there there was no software in the television at all. So, and they were asking whether you want Sony or you want a Samsung or you want what kind of TV, and they had USB drives for every television, and they used to sort of put it at the back from the USB and sort of upload all the firmware from there. So enforcement becomes very difficult sometimes, because if you actually ask the police to conduct a raid and they actually go to the store and there is no TV with, for example, Sony, then they really can't seize that material because there is no infringement that has been done and it's an unbranded television. You really have to first go and place an order, and then keep him pending on that particular front, that okay, we'll come and collect it, and coordinate with the police in a manner such that when they actually do and conduct the raid, there is a testimony television that actually gets seized, and it will not be in hundreds in number, but he will surely have that pen drive, which will probably enable any number of televisions to be configured with Sony software and firmware. So, what kind of practical challenges have you guys faced during raids in particular, and how have you coordinated with the police so as to try and maybe make some sense out of the whole exercise?
So I'll go back. That's a wonderful question, Tarun. Thank you for asking that. I would go back to the example of the PVC pipes enforcement that we conducted in Barnala. So it was again a classic example of what you just cited. This guy was a seasoned infringer, in the sense that he had been doing this for over a period of time. And it was not just our client that he was uh, manufacturing infringing material for. We had realized that he was manufacturing material for even the competitors of the brand that we were representing. And he had the machinery. He could print any name on the PVC pipe. You just have to place an order. And like you rightly said, there are two ways to do this. One is you go, identify, and enforce him, along with the incriminating material, which is the printing machinery here, which shows that the printing machinery would have the dice with which he is printing all different names. So he had dice for all major brands that he was manufacturing. So that becomes your pen drive, like you said. If you identify the pen drive with which he's uploading the firmware, right? That becomes the material that needs to be seized. Because if you do not seize that, you could just be staring at blank TV screens with no brand, like we would have been staring at blank pipes with no brand on it. So it was very important for us to identify the manufacturing facility, because we knew there would be the printing equipment, and that was important to be seized apart from the pipes that we found. But the second way also works many a times, as long as it doesn't put us in a position of abetment to infringement. We do not want to be in a situation where we, encourage him to place an order. We place an order. We encourage him to manufacture products as per our liking, and tomorrow he shouldn't come back and say that मुझे तो ये बोला गया था, मुझे तो पैसा दिया गया था. So that is something that we should be very careful with.
Sure.
So usually during our investigations, we ensure that we reach out and identify the process, the modus operandi under which they are operating, so that we know what is the material that needs to be found, not just the blank TV screens, but the pen drive that he is using to upload, not just the blank pipes, but the printing equipment that he is using to print various brands.
Also, based on your experience, Vincent, how have you dealt with the post FIR proceedings? Because it's not Sony versus that particular retailer anymore, right? So once the raid is done and the seizure is done, and then you go to the police station and you get the FIR registered or instantiated. Post that, it's the role of the police to take the investigation forward and sort of bring it to a logical conclusion, which hardly happens, right? So how are your clients taking care of that aspect? If you can throw some light, practical issues, any tips on whatever your experience has been on how do you enforce post the FIR?
The first thing that we encourage our clients to do is to ensure that you arrange a lot of PR around that particular enforcement. Have press releases, have articles in your own circles, so that it becomes a compelling proposition, not just for the brand itself, but also for the police, because now it is in the press. Now the police has to take necessary actions. It has to move forward quickly than it would have otherwise done. And most of our brands that we deal with, we ask them to do two things. One, which most brands are wary of, they do not become complainants in criminal proceedings. We encourage them to become criminals, because then they would have a bigger foot, in the door, and it becomes important for them to be a part of it. Number one. Number two, a lot of PR, as I said. Do a lot of PR within your own circles. Let people know that you're taking action. The press itself would become a compelling proposition for the police to take action. That is what we encourage.
Also, there are many ways of collecting evidence. You can take a photograph, and obviously there are these camera-based specs or goggles these days that come in. And how actively have you been using those kind of platforms where you capture evidence through the camera, which is surreptitiously placed in maybe a wearable device or in your own pocket or someplace, and then when you've shown it to the police in context, what has been the experience that you've had with such evidence?
I would be giving out a lot of tricks of my trade if I were to disclose a lot on this, but as you rightly said, yes, technology needs to be used. It is being used. Of course, there are glasses with cameras and pinholes and so on and so forth. It is being used, but along with that, we depend a lot on documentary evidence. We try and, in most cases, we try and procure material with invoices, uh, which shows that they are dealing in this particular product. But of course, there would be instances where there are willful counterfeiters who want to keep their identity, uh, uh, discreet, and they would not give out any documentary evidence. In those cases, yes, these tactics do work. Audio, video recordings, photographs, and so on and so forth. And we do keep actively using them.
All right. So Praveen has asked a question on certified copies. I think I can answer that. So Praveen, you can actually request the trademark registry to give you a certified copy of your registered trademark. So it's a matter of a small request, and which upon being made they'll take a few weeks, but issue you. There's no notarization per se of that copy, but it's a certified copy issued by the registry on the registration that you have of the trademark. So that is what I was referring to in the initial part of my session. I'll see if there are any further questions. Can we institute civil and criminal proceedings both? You surely can. It's not that you only can initiate one. And I think you covered all the questions. I'll be happy to we have another 10 minutes that we can attend to some questions. If somebody wants to ask a question verbally, very happy to entertain, and please feel free. You can also ask any questions on the chat box if required. Yeah, Dr. Anil Sharma, I think you have something to. You are on mute, sir. Dr. Sharma, we can't hear you. You are on mute.
Yeah. Now it's okay, sir?
Yes, sir.
Yeah. Very good evening. And this is the first time like I'm just attending a webinar organized by Kurana and Kurana. Love to attend it the same. Quite encourageous. But only one thing that the products and complaints and infringement all being discussed, they all were like related with the consumer and industrial products. So I'll be happy if something can be done on our part also, like Ayurveda or herbal industry. How do we go ahead? Because just couple of days week back, with your help, the ever first patent in hypertension means with Kurana's help we won the and being granted. So I'll be completely novice and new to the industry. How do I go ahead? Will be requiring to and further guidances from your table.
Sure, Dr. Sharma, we'll surely keep that in mind. The sessions
Yes,
are
sir.
fairly tied up. We are all obviously short on bandwidth most of the times, but we'll surely do a session which will be focused more on the pharma industry very shortly, because we do
Yes, sir.
act quite actively in that space. So maybe in that session, we'll try and address more concerns of the pharma industry on the IP
Right,
front
sir.
and modalities.
Yes, sir. Yes, sir. Lovely presentations, and it's quite encourageous on the part of the consumer and the individual participants.
Thank
Thank
you.
you, sir.
Thank you,
Thank
Dr.
you, sir. Thank you, sir.
Any
Bye-bye.
other question?
Yeah, Tarun, I just wanted to understand that at which stage we need to obtain the permission of the registrar in case if we register a FIR under section 103 and 4 of Trademark Act.
It's not really required. I mean, in a very few cases where the SHO is not very well versed with the procedures, when they actually call for a certified copy. But because in most cases the registration certificate being issued these days by email, any which ways, then a simple print of the same is enough for sort of substantiating the registration, and we can always argue that it's a matter of public record and can always be seen online in the online records as well. So, but only in cases where the SHO is not agreeing to, you can either go to the local magistrate and get an order for him, or otherwise in those cases you might have to go back to the registry and seek a certified copy. But again, as I said, it's not a heavy requirement in most of the SHOs that we've conducted raids through.
Okay.
Or Gaurav Khanna also asks a question on the actual punishments that are taking place and what kind of. So I mean, on the imprisonment side, again, as I've mentioned in my slide on civil versus criminal proceedings, I did mention that criminal proceedings are more short-term impact creating exercises and are more of a social embarrassment. So police, I mean, with the kind of relationships that everybody knows that happens, you can always try and sort of get out on bail and let the criminal proceedings go on, and they sometimes go on for years. And because the plaintiff is not the owner of the IP in that sense, the proceedings are between the state and the accused, and therefore the proceedings go at their own small size. We being a witness, you can try to impact as much as possible, but otherwise beyond that, the imprisonment and the fine is not significant enough to actually become a deterrent. The major deterrent is actually the very act of conducting a raid. The fact that you've a good PR would sort of enable more embarrassment to be caused and more social media activism, because it comes in the local paper, his name and his photo can come down. So that is a bigger deterrent than the imprisonment per se, because it is hardly for more than 1 or 2 days at most, and in most cases. Anything, Vincent, from your side on this? All right. There's a question of how do we deal with criminal charges against orders of High Court like bail. I think that will depend on the case in context, and hard to give a generic response to that, because it will depend on what kind of contempt proceedings happened and how grave they were. What does the High Court order say? What were the facts of the case? So hard to give a definite answer to that. Babita asked a question about what if your brand is not, just 1 second, what if your brand is not even remotely similar, but you still get a threatening letter from a registered IP owner? Then I think you have enough liberties available. You can file a strong reply, you can file a caveat, so that even if there is a proceeding tomorrow initiated by the plaintiff or purported IP or owner, you could essentially defend yourself in the court in view of the caveat. So caveats to help you. You can monitor the cost lists, you can monitor the case records, so that case status is so as to ensure that if and when there is a case filed by that company which had sent you a legal notice, you can actually go ahead and defend yourself out, so that your position is made clear and your response to the legal notice is also clarified out. But how to respond to a legal notice, what kind of parameters to consider, is again a topic which would require a separate session, but maybe we can address it surely in another topic, because I think there are many factors and many things that need to be kept in mind while even responding to a simple legal notice. I think we're almost done with time. Vincent has already shared his email address in the WhatsApp, in the chat box, and therefore anybody who wants to reach out to him for any investigation or any other activity associated with criminal proceedings, or wants to reach out to us at Khurana and Khurana, we're very happy to do it. I and Vincent do work on a few projects together on certain occasions as well. So look forward to sort of engaging further on many other mandates, and we look forward to our next webinar soon as well. Vincent, any last thoughts? Otherwise, thank you so very much for joining in and sparing your time, and I look forward to sort of doing more of such events together.
The pleasure has all been mine, Tarun. Thank you for having me here, and I would definitely like to have more webinars and more in-depth conversations with our audience.
Absolutely. And there's a question on the presentation. You can email it to us, and I and Vincent can sort of separately email it to you. Otherwise, this session is getting recorded. It would come on YouTube and also on LinkedIn and other posts as well. So it can be taken up from there as well. Thank you very much again, everybody, for joining in and sparing a very precious 1 hour of your time. Have a great weekend ahead, and pleasure. Thank you. See you, Vincent. Thank you, everybody.
Thank you. Thanks, Tarun. Bye. Thanks, everyone. Thanks for your time.